Welcome back to the morning show here on Arise News. I'm Rafai saying it's been a celebratory day today.
Indeed, and happy birthday to Dr. Abato once again. I am Adesua Omoruan.
And I am Sheto Atigari. I love surprises. Oh, yeah. Now let's change the conversation to the Revolution Now convener, Omoyele Sowore, who has now met all the bail conditions set by a federal high court in Abuja.
However, his lawyer, Femi Falana, confirmed to Arise News that his client has not been released by the Department of State Service. He says the Department of State Service has asked him to come for Sowore at 10 o'clock this morning. That's about a couple of minutes ago.
Meanwhile, the court has adjourned the trial of Sowore and his associate Olawale Bakare to December 5 and 6. Well, Arise News correspondent Ntaganda reports.
During the proceedings, Sowore's lawyer Femi Falana accused the Department of State Services of denying him access to Sowore, claiming that he went to the DSS office almost 10 times. The proceedings took a dramatic turn when Falana alleged a conspiracy between the Deputy Chief Registrar and the prosecution lawyer Hassan Liman. He accused them of making secret arrangements to have the prosecution witnesses address the court in camera. Falana pointed out that Liman brought protective screening instruments to take secret witnesses, a plan he made with the Deputy Chief Registrar without the defense or the court's knowledge. He said the prosecution ought to have made a formal application for such an arrangement. Justice Ojukwu rebuked Liman and the Deputy Chief Registrar in open court for preempting a court order, but then ordered Liman to proceed with his case. However, Falana challenged the decision, insisting that the court should make a pronouncement on the of secret witnesses. His plea fell on deaf ears, as the judge held that no one controls the court. Proceedings were then adjourned until December 5th. Sowore and Bakare were arraigned on September 30 by the federal government on a 7-count charge bordering on conspiracy to commit treason, money laundering, among others. They both pleaded not guilty to all charges. Ntaganda, Arise News.
Joining us now from our Abuja studio is Mr. Akin Sowore, a legal practitioner and a member of the team of the lawyers for the accused. Welcome to the morning show, Mr. Sowore. Can you hear me?
Oh, welcome. Good morning.
Okay.
Yeah, I can hear you. Good morning.
Okay, good morning. So let's get right into it. Now, we are aware that the Federal High Court issued a directive to release Mr. Sowore and Mr. Olawale Bakare, but reports getting to us is after the team got there, as well as the court bailiff, you were sent back stating that they had closed about an hour before your arrival. You're supposed to be picked up this morning. Can you bring us up to speed regarding this morning's event concerning his release?
Well, yesterday it was actually true that immediately we got the release warrant, we took it, the bailiff took it there, and they said in their normal operation that they have closed for yesterday. But by and large, they promised 10 o'clock this morning. And our team, we have arranged our team to go there to serve them, proper, to witness the service that will be taken there by the bailiff of the court. So as of this morning, we have not received any negative report as to that effect. Yeah.
All right, Mr. Akin Sowore, another part I'd like to talk about really is the process of perfecting the bail. How was it? Because the bail conditions were really very tight. How was it like perfecting that bail?
You could recall the other time I was here and I told you here that the DSS and the prosecution side were trying to frustrate the people that are offering themselves for shorties. But as God will have it, after rigorous efforts, we eventually got shorties that came, that had the courage and came. Some of them from United States of America. They've come around to, offer themselves for shorties. And as we speak, we have perfected it, though it was, a tug of war, trying to, secure people. And those initial people that we, secured declined on the basis of the fact that, federal government, after, presenting themselves as sureties, we want to, rope them, and as a result, some of them declined and they went back. But, we didn't, relent on our hours. We charged for people, and eventually people came around, to stand in surety for him. And at the level of about 3 days now, we have perfected, the bail conditions. And yesterday, we have presented it to the court, for the warrant of release after, verifying, all our, sureties and the documents they brought forward. And they have done, and just about some minutes after 4 yesterday, the judge, signed the warrant, only for us to get to the, DSS facility, and they said, they have closed for yesterday and that we should come today. And our men, with the bailiff, are going, they must have been there now, as I'm speaking here. Yeah.
Okay. Trial has been adjourned till next month. We do hear there are reports that prosecution wants to take in witnesses into the chambers, or secret witnesses, as it's called. Do you know if the court has granted this, and what form exactly would this take in the instance of secret witnesses?
Of course, the arrangement was strange to, especially the process leading to the, approval for such an arrangement, was an alien to, our practice in Nigeria. Of course, we could have a situation whereby a secret, witnesses could be, brought in that manner, but it has to be through the leave of court. But in that of yesterday's, it was like a coup, trying to ambush, the defensive, party, bringing in shots, witnesses through the back door, getting approval through the deputy, registrar of the court, without the, notice of, our team. We felt, very, very bad, and it was very sad. And our lead counsel, Falana SAN, rose to the occasion, and he, objected it. And when it became glaring to the whole world that it was a rape of, justice, was an aberration to our legal system, the judge quickly, called the deputy registrar, scolded him in the open court, and he said something of that nature cannot happen in his court, even though when what their plans was partially, seemed to have been granted by trying to, force witnesses on us when we were not ready and were not served in compliance with what the Constitution says. The judge, wanted the matter to go on until our lead counsel cited several authorities, frowning at that, since we have not been properly served to prepare our defense against whatever the witnesses must have put in place as testimonies. So, of course, after much argument on that one, with the aid of legal aids and authorities, the judge played down on that and agreed with us, and the matter was adjourned till December 5th, 2019, which is about a month to come. Actually, it was out of the brilliant advocacy of our lead counsel, we would not have gotten that. They will have started the matter yesterday, even though when it does not comply with the normal rules, or the constitutional provision that says we must have the time.
Okay, Mr. Akin Sowore, we'll come back to you very soon, but we'll quickly just need to take the judge at the International Criminal Court about to pass a sentence on Congolese warlord Bosco Ntaganda, known as the Terminator, who was convicted of 18 counts of war crimes and crimes against humanity. Ntaganda became the first person to be found guilty of sexual slavery when he was convicted by the Hague-based ICC in July 2019. The Rwandan-born 46-year-old has appealed against his conviction. So right about now, we'll go to The Hague in the Netherlands and see more proceedings as a result of this.
FPLC, in relation to events that took place in the Ituri district of the Democratic Republic of Congo in 2002 and 2003. On or about 20th November 2002, the UPC FPLC launched an assault on Mongvalu, which is in the Baniali Kilo collectivité. After it took over Mongvalu, the UPC FPLC also captured Sayo, Kilo and Zebi. In February 2003, the UPC FPLC launched a coordinated series of assaults on several villages in the Valendu Diatsi collectivity and took control over the villages of Lipri, Tsili, Kobu, Bambu, Buli, Gola, Yichu and Nyangarai, as well as some surrounding places. The majority of the crimes that Mr. Ntaganda was convicted of were committed during these two operations. In addition, Mr. Ntaganda was convicted for the conscription and enlistment of children under the age of 15 and their active use in hostilities, as well as for the rape and sexual slavery of some of these children. The Chamber convicted Mr. Ntaganda as a direct perpetrator pursuant to Article 25, sub 3a of the statute for one murder as a crime against humanity and as a war crime, and for persecution as a crime against humanity. He was convicted as an indirect co-perpetrator pursuant to the same provision for the other murders and acts of persecution, as well as for all of the other crimes. On the same day as it delivered the judgment, the Chamber ordered the prosecution, the defense, and the legal representatives of victims to file any requests to submit further evidence or to call witnesses in relation to sentencing by 29 July 2019. Following requests from the parties, the Chamber authorized 3 witnesses to testify before the Chamber in person and admitted into evidence the prior recorded testimony of 5 more witnesses, as well as several documents and videos. On 17, 18 and 20 September 2019, the Chamber held a public hearing on sentencing, during which it heard the aforementioned 3 witnesses and oral submissions of the parties and the legal representatives of victims on the sentences to be pronounced. On 30 September 2019, the parties and legal representatives filed their written submissions on the sentencing and responded to each other on 8 October 2019. I will now briefly set out the legal framework that the Chamber has applied for this judgment. The Court's statutory framework established a comprehensive scheme for the determination of a sentence. Also, Articles 77 and 78 of the statute do not specify the purpose of punishment for crimes under the statute. The preamble establishes retribution and deterrence as the primary objectives of punishment at the court. Retribution must not to be understood as fulfilling a desire for revenge, however. It rather is an expression of the international community's condemnation of the crimes. By imposing a proportionate sentence, the harm caused to the victims is also acknowledged. A sentence should further be adequate to discourage reoffending and to deter those who may consider committing similar crimes from doing so. The Court's legal framework does not contain mandatory minimum or maximum sentences or sentence ranges for specific crimes. Article 78, para 3 does, however, provide that any joint sentence of imprisonment may not exceed 30 years unless the extreme gravity of the crime and the individual circumstances of the convicted person warrant a term of life imprisonment. The Chamber enjoys broad discretion in determining the sentence, but the totality of the sentence must be proportionate and reflect the culpability of the convicted person. Basing itself primarily on its findings in the judgment, the Chamber considered the gravity of the crimes first generally in abstracto by assessing the constitutive elements of each crime in general terms, and then in concreto by assessing the particular circumstances of the case, looking at the degree of harm caused by each crime and the Mr. Ntaganda's culpability in relation to thereto.
Right, you've been watching the sentencing of Bosco Ntaganda there by the ICC that's based in Hague, and we all know the story. I mean, but for those that don't know the story, just watching us, I mean, the story has been on for a while.
He was convicted earlier this year. This is just a sentencing.
It was convicted earlier this year for pretty much war crimes, pretty much indicative of what the likes of Jose Kone did in the Congo. Raping of women, sexual assault of women, sexual slavery, as it was called. Recruiting underage soldiers. Pretty much the elements of the likes of Jose Kone with the Lord Resistance Army and the likes. And he was nailed. In fact, when the story first broke, there was a big controversy about, because the chief prosecutor of the ICC, Fatih Bensouda, is a Guinean woman. So there was a back and forth about, an African prosecutor, another African. But, you need to account for the law, and you need to face what you have done. But some watchers will say that when it comes to the ICC and their prosecution, sometimes it goes only after African. The only case you would look that a foreigner was convicted was Slobodan Milosevic, and that was the Bosnian Serb leader. And after that, we've not really had any conviction. And even the likes of Laurent Gbagbo recently is almost a free man these days. But we'll continue that proceedings. We'll watch it as time goes on. We'll see what the sentencing would be like. But we've heard a big clause. It might not be more than 30 years, like the judge was saying there.
He has denied the charges, and he's also dubbed as a terminator. He says that does not relate to him anyway. But we'll keep our eyes on the story. And we still have Akin Sowore, a legal practitioner, a member of the legal team for Omoyele Sowore, convener of the revolutionary protest. Rufai, before that introduction to The Hague, you had a question for Mr. Sowore.
Yeah, I had a question, and I wanted to talk about this new pattern we're seeing now of secret witnesses. Because, I mean, if you look at the case of Agba Jalingo, too, the people in that matter, too, are saying we want to bring in secret witnesses. Now, Sowore's case, this is another pattern. Is it only me watching it? Are you reading it the way I'm reading it? And what's your inference from this?
Hello, Fadi, you are trying to compare between the footage we just watched and that of Sowore.
Secret witnesses, secret witnesses, people that the state have had an impasse with, they always ask, to bring in a secret witness or to make the witnesses to support their side of the story secret. So is it a new pattern you're seeing, or we're just rabble-rousing, as it were?
Hello?
Okay, can you hear us properly, Mr. Akin Sowore? Can you hear me?
Yeah, I'm with you now.
Good.
I'm with you now.
I said I just want you to talk through this pattern of secret witnesses, on the part of the states when they have, problems with journalists or people they say, they're trying to topple the peace of the state. In the case of Agba Jalingo, if you follow that case too, he's still in custody. Is just in that same case. What would you like to say around that?
Well, the point is that there's nothing, there's no reason for the call for, secret, witnesses in this regard, because in the first place, this matter is a political. The trial is a political trial, and we believe that there's nothing in that trial. The offense mentioned, charged, were frivolous, and as a result, we don't think they really have, he really has any matter to actually fear about. About the secret, witnesses that they are trying to call. The other time I talked about, the government callousness, in trying to, victimizing people in Nigeria. Ordinarily, in Sowore's case, there is nothing that has called for, secret witnesses in this regard. If anybody is competent, if anybody has anything to say about him, the person should be bold to come out without being masked or without being hidden or being put in camera for any witnesses. It's all calculated attempt to rape justice and to involve in secret trial that we always come about trying to indict him at all costs. So that is just all about that. Ordinarily, you don't ambush in the court practice or in court process. You don't ambush your position. You evade your position with all that you have against him, all the witnesses, their statements, and all the rest that they have against him. And in turn, the opposition will now file, according to what they are served. The witnesses must have said, so that that's the reason why we call it defense, that he will be able to defend himself. So, but in this regard, if you do any arrangement that is different from this, trying to, come through the back door, to actualize, justice, it doesn't work. It's a rape of justice as far as we are concerned. It's alien, the practice, and it's unfortunate, very, very callous of the government, and it's indeed, part of the misrule, the tyrannic and oppressive way, of adjudicating, justice in Nigeria presently. So it's a thing that we will not agree and that we always frown at and that we will not condole. So by the grace of God, we at the level yesterday, we have done tremendously to stop that, and we are still on it. We will rebuff any form of secret trial in that manner.
Okay, with this your line of submission, I mean, you say it's a rape of justice and so on. I wonder, how confident are you in this trial? And do you know how many witnesses the prosecution is likely to call, as well as how many witnesses are you calling? And how long do you envisage that this trial will go for?
Well, the point is that this trial, we are very, very confident about this trial because we have seen several cases like this in Nigeria that the government will, trump up, and at the end of the day, it won't hold any water. This one will be one of them that the government will fail because in the first place, all the assertions, all the allegations were unfounded and they are not known to law. All the charges that they trump up and they brought forward are unknown and they are not, connected. It's not connected. It's an innocent as far as we are concerned. And if it is like that, we have seen several authorities, several cases in that line that has failed in that line. And so this one is going to be one of them, like I say. And it's not in tandem, with the normal practice and the justice, adjudication in anywhere in the world. So this particular one is just a mere, political vendetta against anybody who is trying to, obstruct government or criticize government. Somebody, when we are talking of revolution or talking of, whatever they call it, revolution is somebody must have been armed, planned the arm, or confront the government with a force. So where is a person that does not have is not a militant, is not a military, and he doesn't have any arm, no evidences of stockpiling arms, against the government. It's just a mere, idea, about how Nigeria could be, made safe for the people, calling for, a situation whereby people will be, free from this oppression that we are in Nigeria. A dramatic, departure from the oppression, the tyranny, and the misrule that we have in Nigeria today. That is about, the idea of what we were trying to do. And in doing that, he has not committed any offense that he could be charged for all this. So at our level, we have a solid defense team who will tackle them along, with the law of the land. And we are very confident that we are not going to be, fear about anything in this matter. So about the length of the time that the thing could take. Of course, as far as we are concerned, this is a matter that is frivolous. After one or two objections, it will be struck out because we will lack locus in the first place to bring a matter that does not exist. And any matter that is not actionable in this form will definitely fail. So that is where we have the solace that the matter won't go far, because by the time we are starting now on a very wrong footing, trying to come up, bringing in, witnesses through the back door, which does not exist. That we have sent signal to people that this one is frivolous. There are a lot of people, it matters a lot of cases that we have procured in this country. If anybody has any genuine, issue against anybody, the person should come in the open and come and say it with all evidences. Not about somebody trying to speak behind the scene or trying to be in camera, trying to, cook up something that is not real. So from ab initio, we know the matter, has failed, and by the grace of God, it's going to fail. Except we are not following what the law says in Nigeria. Nigeria is a democratic state where we have laws, rules and regulations that are governing the affairs of both the subject and the rule. So in this regard, we know quite well, the whole world knows that the government is just being tyrannic. The government is just being oppressive. The government is just trying to deviate from the norms of democracy that we are cherishing. So it's about freedom of speech. It's about freedom of association and freedom of expression. It's all about that. It's not about any coup or anybody trying to overtake the government like they posited in their allegations. So all is about the wickedness that we have found ourselves in Nigeria, and that we are going to combat that, and we are going to fight the government to a standstill, especially if they decide to continue in this form.
Mr. Sowore, still speaking about the timing in regards to this upcoming trial. Now, we know that Mr. Sowore has been locked up for, over 100 days, and his lead counsel, Mr. Femi Falana, has actually said that the DSS has refused his seeing of his client, that there was a restriction, and it has hampered the defense for the legal team. Now, with hope that he's released today and the start date of this trial being December 5th, is that enough time for the legal team to prepare for this upcoming trial?
Of course, in our parties, as as a court in Nigeria, well, we have the understanding of both the legal team in line with court and all the people that are concerned. We have to reach a consensus before we agree on a date. And I think that was done at the level of court yesterday. We hope that time will be enough for us. Of course, we are not lazy lawyers. It will be enough for us to package our, defense, especially since we have been served yesterday. So we are competent, and the time frame will be okay for us. Of course, what we have agitated is that we should be served properly. We should be given the opportunity to peruse what the witnesses must have put together as their testimonies, so that we can actually defend whatever allegation they must have put up there, or whatever fallacies they must have told in that their briefing there. So that is exactly what we have demanded yesterday, and we started perusing it, and from there we will bring our own side of story. We package it and make it a defense. That is exactly what the law says. That will be an accused person or the defendant will be given enough time, to prepare his defense, so that it won't, amount to, lack of fair hearing. So in this regard, a month time will be okay for us, and we are very sure that the matter won't take a long time, because in a matter whereby before even the starting, we have seen the floor. Okay. We have seen all the father. Okay. That. Okay. Yeah. Okay. Mr. Akin Sowore, we'd like to say a very big thank you to you, and we hope that this is perfected, and Sowore too keeps to the terms of this agreement, like not addressing the public while he's out of custody.